Citadel Santiago Jones, 17 CH 1710, which is consolidated with 21 CH 408. Council and parties, go ahead and introduce yourselves for the court reporter, please.
Tim Johnston for Jason Jones, 17 CH 1710.
I am Michael Strauss of Strauss and Hoyt on behalf of Citadel Jones in case number 23 OP 220.
Be expecting Mr. Parrots, who, as I understand it, represents Mr. Jones in the OP matter, had represented him.
I did give him notice of today's date. Just like myself, he found out about this order yesterday.
All right. Well, there's a lot of feedback. I'm not sure where that's coming from.
I think Carrie, I think it's yours.
Sorry, there must be something else. And now everything is going.
There you go.
Perfect. All right. Well, I am inclined to grant the motion to vacate.
I'd like to be
here, but Mr. Johnson, I know you don't have an appearance in the OP case, but obviously it will affect your case in some respect. And I'll have to take up that matter after I rule on the OP issue.
Oh my God.
The only thing that I would add, Your Honor, that I think you should be made aware of that is not part of the petition, and perhaps before Mr. Johnston speaks, is that Mr. Johnston and his client came to the house when the OP was in effect. The police were called. My partner, Deanna Hoyt, was involved in talking directly to not only Tim, but also to the police. So everyone was well aware of our involvement in this case. There's no possible way that Mr. Johnson could say he did not know about us, and yet this order got entered. So I will leave it at that with what I put in the petition that I know you've read already.
All right. So I guess, Mr. Strauss, do you object to Mr. Johnston arguing against your motion, given the fact that he doesn't appearance on behalf of Mr. Jones in the OP proceeding?
I mean, obviously that is exactly the problem with the fact that this order got entered, but no, he can argue it.
All right, Mr. Johnston.
Your Honor, I disagree with the motion in its facts, in its law, in its premise, and I oppose it. I told you initially that I emailed with Mr. Odo, and I emailed with Mr. Minetti about client verified. His client's on the call, and I think she should be questioned about her verification, Your Honor. She said in a verified document, which Mr. Strauss signed, per Rule 137, she had no notice of this. That's absolutely a fundamental mistruth. Okay, that is a lie. Specifically, we sent her notice of this on March 15th. That is what my notice of filing says. Okay, we did that. We sent to an email. I can show you the email. All right, March 15th, we sent that to her.
Notice of what?
Notice of motion on the rule to show cause, which was then heard by you on March 23rd. That was after we were not permitted to be in the house. And you remember that was, and that motion I know is very fresh in your memory. So she absolutely had notice of the 323 meeting. And I can screen share you, I can show you the email. I can show it to you right now, Judge. Plus, it's in our filing. You'll see a file stamp notice of motion stating that we served it to her. And how did we serve it to her? We served it to her via email. Why do we serve it to her via email, Judge? Because that's exactly what you told us to do earlier in this case. Back when we were in courtroom 307, you'll recall, this is probably 4 years ago, we were having extreme difficulty getting the house inspected for the first time. During that time frame, which is shortly after Mr. Diambri withdrew, you ordered Citadel to file an appearance. She has never appeared in this case. Okay, she has not appeared in this case. So whether or not Mr. Strauss can file into this motion file this motion in as a prerequisite question, I don't know, but she hasn't appeared in this case. But during that same time frame, when all the attorneys were having such difficulty working with her, you ordered that service to Citadel would be via email. That is substitute service. So when in this verified motion, multiple times, they say no notice, that's absolutely not true. 100% not true. Furthermore, Mr. Strauss's citations to the statute that he cites, 750 ILCS 60/224, he cites sections B and section C. Section D of that I'm sorry, no, it's not section D. It is section F. Specifically says, this section does not limit the means otherwise available by law for vacating or modifying orders of protection. Now, Mr. Strauss's motion says that there's an emergency. What is the emergency? He says that the emergency was that this order was entered, and that's the emergency.
Well, I think the emergency is that my order required this inspection of the house to take place this afternoon. So I'm fine with the fact that it's been filed as timely as could have been in terms of when he was aware of it and when the event that it caused him to file this is going to occur. It is supposed to occur this afternoon. So I don't have a problem with the fact that the motion was noticed up as an emergency based on that, because otherwise, hypothetically, his client would be potentially in contempt of court for my order, and he didn't want that to happen, so he filed a motion. So I'm fine with that.
Your Honor, may I? Oh, I'm sorry. I mean, at some point I'd like to respond because there's some, frankly, ARDC-like grave misstatements.
All right. Anything else you wanted to say, Mr. Johnston?
Your Honor, I'm not in the practice of accusing people of ARDC violations or saying that I need sanctions at the first time I file a motion. I make a phone call. I never received a phone call from his office on this one. I think it's absolutely ridiculous that he can't make a phone call before he files a motion asking for sanctions. We disagree fundamentally with this. And fundamentally, what I'm gravely concerned about is this is going to cause a continuance of our trial. We've got a trial date in May. My client has a right to conduct this inspection. The Citadel is the reason why we can't do this. I don't know why we can't work out something where either she absents herself for the probably less than an hour time this takes, or we just work something out. I don't know why it has to be this way. It's my understanding, I was not there in court, but it's my understanding in Judge Fizz's courtroom that Judge Fizz spoke to Mr. Strauss and spoke to his client about this and said the inspection is going forward as a modification of the OP. That is my understanding. I cannot testify to that. I wish I could. But it is no surprise to anybody here. This has been for you.
All right.
Thank you. Thank you for hearing me out.
I'm granting the motion to vacate the order that I entered on March 31st. Now, Ms. Jones will have her own issues in our chancery cases. But at the time, there was an intervening event. In other words, I had ordered this inspection to take place, but that was, as I understand it, at a time when there was not an order of protection in place, and the order of protection then came in place. So when you moved to hold her in contempt for not allowing you into the house on, I can't remember what day it was, but I believe it was a day after the order of protection had been entered. So on that basis, I concluded, I couldn't hold her in contempt for not allowing Mr. Jones into the house because there was an order of protection, sort of an intervening event, if you will. All right, so just to be clear, I am vacating the order. I will draft an order vacating my order March 31st, 2023.
Your Honor, I think you mean March 23rd. The order of March 23rd.
Is that the date of my order?
Well,
yes. All right. So yes, I'm sorry. I'm amending my order of March 23rd, which was modifying plenary order protection on March 16th. I will prepare that order. I will get it out. So now
Your Honor, as a point of
So
clarification.
hang on a second. So I still have the issue of at 4:30 this afternoon, Mr. Johnston and Mr. Guadarrama are going to be able to go into the house and inspect it and videotape it and take photos. So my question to you, Mr. Strauss, is are you representing Ms. Jones with respect to the CH cases that I now have to address and get at least the attorney and the expert into the house? And I'd like to do it this afternoon at a previously prearranged time and date.
So I'm not representing her in the CH. She is here, but there is no objection to Mr. Johnston and any expert entering the house. The only objection is to Jason being in that home. That's it.
All right, then I'm amending my order of March 31st, where I directed Ms. Jones to allow and make available for inspection the premises. I'm going to amend that order to provide that counsel, which is Mr. Johnston, and the 213F3 expert, Mr. Guadarrama, shall be allowed to be present in the home and on the property at 4:30 this afternoon, and shall be allowed to take photographs and video of the interior and exterior of the house. So I'm going to enter that order amending. So I'm going to enter two orders: one, vacating the order modifying the order of protection, and two, amending my March 31st order in the CH cases to remove Mr. Jones as someone who will be entitled to go inspect the property this afternoon.
Thank you.
Your Honor, my question was about the 331 order, which you just addressed. You know my position is that Jason needs to be there to help me and help my expert analyze that. You've heard all my arguments on that. I'm restating those, and you understand those arguments.
I do appreciate that issue. That's why I'm going to expand the little order a little bit to allow you to video or photograph so that, you know, you can go back with your client and he can walk you through what you're seeing. Ahead of time, he can tell you what he wants you to be focused on, what he wants you to look for. You can take as many photos, as much video as you want, and you'll be able to review it with Mr. Jones. Under the circumstances, I think that makes the most sense. So that is what I will do. I will get these orders out to you as soon as I can this morning, so that you will have them before 11 or 12 today.
Thank you.
Thank you.
Any questions?
No, thank you so much.
All right. Thank you very much. Have a good day.
Take care.
Nice to see you, Ms. Vall.